Finally, we get to consider remedies. I think remedies is just about the most important subject on any bar exam in the United States. And it's interesting that I would hold that opinion, given that remedies often isn't even listed as a separate subject. But as you work your way through these videos with me, I think you'll come to see that remedies is at the heart of all civil litigation. A plaintiff has to have a theory of liability and a prayer for relief. And if we're going to think like competent plaintiffs' lawyers, we're going to come up with as many valid theories of liability as we can and as many persuasive prayers for relief. If we're on the plaintiff's side, we want to be able to get our clients everything that they are entitled to. And if we're on the side of the defense, we have to be as comprehensive as possible in defending against the various prayers for relief brought by the plaintiff. Now, as we consider remedies from above, looking down on the whole subject, we see that it consists of three big areas: damages, restitution, and equitable relief. And as we get into the fine print, we see that the distinctions between these three areas, the boundaries between them, tend to be a little bit gray at the edges. Still, having a fundamental grip on the basics of this material is extraordinarily helpful because it allows you to create answers that are more rigorously organized and more complete, not to mention more intellectually valid. Remember, on an essay, in any jurisdiction in the country, the goals are spot the issues, organize carefully and well, and probably more important than anything, analyze the facts as carefully and as specifically as possible. So, let's get into considering contracts remedies. Now, I've just said the big picture of remedies includes damages, restitution, and equitable relief, which here in contracts is specific performance. But if you look at the little outline that I've presented to you, basically derived from the National Conference of Bar Examiners, you'll see that restitution isn't listed. The word restitution doesn't appear in the outline. But look down to quasi-contractual relief. Quasi-contractual relief is founded in restitution. Now, the reason that it is listed under damages is because a successful plaintiff will achieve a monetary award. But intellectually, it's very important to make the clear distinction between a damages remedy and a restitutionary award of money, quote-unquote, damages. Because a restitutionary award really isn't damages, even though it amounts to a very similar-looking scenario in which the defendant cuts the plaintiff a check. But remember, the real difference between damages and restitution is the party that we're looking at. With damages, we look at the plaintiff, and our goal is to make the plaintiff whole. In restitution, we're looking at the defendant, and our goal is to avoid unjust enrichment. That's the key intellectual distinction, and if you really understand it and can apply it to a given fact situation, you're well ahead of many of the people that you're competing against. Personally, I don't think this is terribly subtle, but in the practical realities of life, this is an area that tends to trip people up pretty severely. So, now focusing on damages in contracts. First, let's examine the UCC. Remember that damages are by far the preferred remedy in the UCC. Equitable relief is available. Specific performance is a possible remedy for the breach of a UCC contract. But it's not the preferred remedy. The reason for this is goods are fungible. So, in order for a specific performance remedy to be appropriate, something has to happen factually to make the cover remedy impractical. Now, with regard to calculating damages under the UCC, where a buyer breaches, either party, the seller, may withhold delivery and or get damages. And if the seller withholds delivery, the damages would be measured by lost profits. The beauty of the UCC is how it streamlines contracts formation and how it quantifies contracts damages. The idea of an economic breach is really only a product of the UCC. The idea of an economic breach is where a defendant breaches a contract willfully in order to obtain a high enough profit in another deal that the defendant can compensate the plaintiff for lost profits and still be ahead. So, this is a very different mental frame of mind than common law contracts. Under the UCC, we're looking to make money. If we have to breach a contract to do it, that's okay, as long as we're able easily to compensate the non-breaching party and make everybody whole. Now, where the seller breaches under a UCC agreement, a buyer can reject non-conforming goods, or cancel, or cover and get damages based on the costs of cover. Now, that's a fairly glib statement of the rule, but I advise you again, as always, go into practice. Take a look at how this material is tested. Damages under the UCC are tested in a very ritualistic fashion. There's only a handful of different scenarios, and once you master them, you're ready to go. And it requires a little bit of patience and perseverance. But really, the magic key that unlocks this is practice. Studying the material in a vacuum is not very practical. So, I'll give you some more information, and then I'll encourage you to go out and work on this material in a practical way. That's how you will expand your knowledge. Now, considering a non-UCC damages issue, let's turn to land sales contracts. Land sales contracts. Here, we will measure damages based on the difference between the contract price and the fair market value of the property. Those are damages under a land sales contract. But remember, the preferred remedy for a land sales contract is specific performance. And the reason for that is all land is unique. So pause for a moment and consider the differences between the preferred remedy in a land sales contract and the preferred remedy under the UCC. Under the UCC, goods typically are fungible. Damages are the preferred remedy, and where everybody in the game is a merchant, we're going to play pretty fast and loose, both with regard to contracts formation and with regard to breach. But where we're going to equal up and settle our accounts will be in damages. And land sales contracts are dealing with unique property, not fungible goods like the ones that are covered under the UCC. So with regard to a land sale contract, usually the preferred remedy is going to be specific performance. Another area in contract law where damages calculations are commonly required are construction contracts, contractor questions. These are very common on the multi-state and also on the essays. So, with regard to construction contracts, there's really two alternate scenarios. One where the owner breaches and one where the contractor breaches. Where the owner breaches, the builder gets profits on the whole deal plus costs or the full price of performance plus interest under the situation where the construction is complete. So, again, to consider construction contracts where the owner breaches. Two possible variations. Number one, the job is incomplete. Number two, the job is complete. The easier of the two is where the job's complete. There, the contractor is entitled to damages plus interest from the time performance was due. Where the job is incomplete, under those situations, the buyer is entitled to his or her profits on the whole deal plus costs, or in the alternative, full price plus interest where the deal is complete. Now, how about where the builder breaches? And the builder is going to breach prior to the completion of the project always. So, where the builder breaches, the owner gets the costs to complete plus any reasonable compensation for the delay, and often there is an offset to compensate the breaching contractor in order to avoid unjust enrichment. So here, look at the situation from the perspective of the owner. What is the owner contracted for? A repaired or a built house or other structure. What is the expectation? Well, the owner expects to pay a certain price, get the development completed by a certain date. So, if the first contractor breaches after having performed, maybe even substantially, the expectation of the owner doesn't change. So ultimately, the owner has to get some other contractor to complete the job. There will be some damages as a result of that process, and plus the owner is going to have to spend money to have the job completed. But when we look back on the deal after the job is done, what the contractor is entitled to is a completed project for a certain price. If the second contractor didn't require that enough money to make it more than the contract price, then there is going to be the possibility that the owner could be unjustly enriched. Under those circumstances, the breaching contractor has a right to a money award. But remember, that money award will be in restitution to avoid the unjust enrichment of the owner. It is not really a contract breach damages award where we focus on making the plaintiff whole. One central idea with regard to breach of contract damages, both under the UCC and under the common law, is punitive damages are not available. A mere breach of contract, even one that delights the breaching party in the process, is not one that is going to allow for punitive damages to be awarded to the non-breaching plaintiff. In order for there to be a punitive damages award arising out of a contract, there's got to be either fraud, which is a tort theory, not a contract theory, or a breach of the implied condition of good faith and fair dealing. And remember, the more egregious the act of bad faith, the more likely that punitive damages will be available, and the more likely that a substantial award of punitive damages will be given. Also remember, with regard to all contracts damages issues, both in the UCC and the common law, and by the way, in all civil litigation, so torts and property apply here also, the plaintiff has a duty to mitigate damages. So once the contract breach is complete, or once the tort or other theory of liability is complete, the plaintiff still has a duty to mitigate damages. So if there are clear facts presented that afford a party that is basically a victim to reduce his or her exposure to harm, we're going to require that party to take those steps, generally speaking, or the defendant will not be liable to the extent that those damages could have been prevented. Liquidated damages clauses also are commonly tested. I like to think of liquidated damages clauses sometimes as being an alternate to performance. But the basic idea, the core that you need to know about liquidated damages is they've got to be reasonable. To the extent a liquidated damages clause is punitive or unilateral or unfair, it won't be enforced. But to the extent that the parties have foreseen possible difficulties arising out of their contract and have made reasonable provision for those difficulties, that will be a strong liquidated damages clause and it will be upheld. But remember, a liquidated damages clause theory is not exactly the same thing as a damages theory. With damages, we just look at the contract and try to make the plaintiff whole. With a liquidated damages clause, we examine the clause itself and the relationship between the parties, and we pass judgment as to whether or not that liquidated damages clause is fair. The more fair it is, the more likely it is that we will enforce the liquidated damages clause. I advise you on an essay that the liquidated damages clause analysis belongs in a separate paragraph or a separate couple of paragraphs than your general discussion of contracts damages. Liquidated damages is a refinement. You ought to consider it separately. Next, we consider quasi-contractual relief. That's the next line item on our outline. But remember that here we're not really dealing with damages, even though there's a money award involved, and even though it fits right here into a discussion of damages. But remember, quasi-contract is a restitutionary theory of liability. It's not really a damages theory. And the way that we can tell is because we're focusing on the defendant and not on the plaintiff. Damages equals making the plaintiff whole. Restitution equals avoiding the unjust enrichment of the defendant. It really is that simple. So, where we have a contract that fails, for example, a contract where the defendant has a valid defense to formation, or where the defendant has a colorable defense to breach, there may still be the possibility that the plaintiff will prevail not really under a damages theory, but under a restitutionary theory where we seek to avoid the unjust enrichment of the defendant. So, we look at the outline and we see that where there is a failed contract and one party would be unjustly enriched at the other's expense, quasi-contractual relief can be presented to impose a remedy that will prevent that unjust enrichment. Also, notice that a quasi-contractual theory can apply where there isn't a contract between the parties at all, but where one party confers a benefit on another party with a reasonable expectation of receiving reasonable or fair compensation for that work, at the express or implied request of that other party, we're going to just imply a contract, but we'll call it a quasi-contract since it isn't express, and we will impose a restitutionary remedy that focuses on the defendant. Now, there are a couple of other remedies that are specific to contracts that I want to mention before we get to equitable relief. And these are reformation and recision. Reformation equals fixing a contract that has some problem. Recision equals cancel a contract altogether. Now, the most common way that a reformation issue arises is with regard to either a unilateral or a mutual mistake or an innocent or fraudulent misrepresentation. What we do under these situations is we rewrite the contract to reflect the true intent of the parties. It's also the case that scrivener's errors often require parole evidence to resolve, and the remedy is reformation of the agreement to reflect the parties' true intent. The defenses to reformation include laches, too much time elapsing, the sale of the goods to a bona fide purchaser for value. Recision is where we cancel the agreement altogether. The two big causes or justifications for recision are a mistake that is material and goes to the very heart of the agreement between the parties, or a material fraud or innocent misrepresentation that equals the same result, a complete mistake that defeats the purpose of the agreement. Here, the non-breaching party may rescind and sue for damages or restitution, depending again on the facts. But the basic idea for rescission is the contract will be deemed canceled. It can be a remedy awarded by a court, or it can be something that a non-breaching party does as a result of a repudiation on the part of the other party. Remember, with a repudiation, the non-breaching party has got options. The non-breaching party can sue now, can sue later, and can seek further assurances. Where one party walks away from the agreement, typically the other party is justified in doing so as well. And that leads us to the last issue that we'll consider in contracts remedies, and that is specific performance. Here, a party comes to court not seeking damages, but seeking a court order forcing the other party to perform. Remember that equitable remedies really are the last remedies or a last resort that a court will take, using its most extreme power in order to impose a result that will be more fair than some other result. So the most important thing about equitable relief, once we acknowledge that it's the last resort, is to know the elements of equitable relief. And so we just rehearse them. The most important and threshold requirement is that legal remedies be inadequate. And what that means typically in contracts cases is damages aren't good enough. Typically, we will either have a unique chattel or we'll have real property. Remember, in both of these scenarios, most especially with regard to real property, specific performance is the preferred remedy. Damages is really secondary to what an aggrieved plaintiff really wants, which is performance. Next, the plaintiff has to prove a definite and certain contract. Typically on an essay, we will have discussed the validity of the contract earlier. So at this stage in our written analysis, we can incorporate by reference from above and prove that there is a definite and certain contract. Next, it has to be feasible for the court to order equitable remedies. That's why services contracts typically can't be enforced. There's a feasibility issue, and of course there's a 13th Amendment slavery issue as well. Forced servitude has been out of fashion in this country for more than 100 years. Next, the least important element of equitable remedies in contracts is mutuality. mutuality has atrophied almost beyond the point of no return. It can come up, and I will try to show it to you, but typically we will more or less imply mutuality. And then, finally, we will consider the defenses of the defendant. And all defenses to equity can be brought to the defense against a specific performance order. The most common defenses are laches, too much time has elapsed before the party has sought relief, and unclean hands. Remember, a party that has not himself or herself behaved equitably is not entitled to equitable relief. And it is typically the case in complicated contracts questions that both parties have not performed to the letter of the agreement. To the extent that the party seeking equitable remedies has not scrupulously followed the agreement, that party is much less likely to achieve an order of specific performance than a party with fully clean hands. And again, remember that the sale of the goods to a bona fide purchaser for value and without notice also will cut off equitable rights under contract law. And that wraps up a reasonably thorough and comparatively lengthy discussion of contracts remedies. Remember, this is the part of the outline that you will learn the least by studying a lot. This is the most practical part of the contracts outline, and you're going to learn the most about it by doing as much practice as you've got the time and patience for.